got you. Well, you didn't find my connection directly with Ditchley, because you said Ditchley was referred to in looking beyond, through the looking glass.
Yeah.
Well, I mean, that's the connection. I did once write a book about, I'm surprised you haven't read it, it's about economic regulation. And somehow it got into the hands of a reviewer from the LA Times. I don't know why, it was a rather academic book. But this is his beginning. He says in Alice in Wonderland, he says in Alice in Wonderland, Alice and the Dormouse emerge from the pool of tears, and the Dormouse begins to read from Hume's History of England. Why are you reading that, said Alice. Well, says the Dormouse, we're wet, and this is the driest thing I know. Well, that was before Breyer wrote this book. So, this book is not about that, and this book is about the court, and I want to show you what our docket's like, so it's a potential for a little dry. But I thought, now, how should I really go into that today? Because there isn't one person here who isn't preoccupied with Brexit, thinking about Brexit. I mean, I certainly am, and so is everyone else. And so my first thought was, I wonder how that will go over. Is there a connection? And the more I thought about it, the more I thought, yeah, there is. What? Well, we're not part of the EU. And what that comes as a surprise to some in Washington. We're not. And yet the problems, as you will see them, are not so different. Not so different. Not going to go away or change radically. If we have them, you have them. And so do a lot of other countries. And I want to talk about some of those problems. And also, if I'm really honest about it, one of the reasons I wrote this book was because there are some in our country whose basic view, and I can understand it, I don't necessarily share it, but I can understand it. You see, if I take this document out, which is our Constitution, and I start talking about foreign law, or how what goes on beyond our shores affects us, they'll say, but don't you understand this is an American Constitution? So I said, of course it's an American Constitution. And I would like to show you how the values that are embodied in this Constitution, which are really not so different from the values embodied in many documents in Britain, that the best way to apply them and the best way to keep them is to know what's going on beyond our borders. You see, now I'm not saying you have a problem like that, but it is possible. So possibly from the point of view of motive, from the point of view of example, it's not so different from what's going on now here as at first one might think. But what am I talking about? What examples? I've been on the court for a while. I've been there more than 20 years. And I've seen things change in this direction. 20 years ago, if I were honest and asked, how many cases out of the 70 or 80 that you hear during the year, you actually really have to know something about foreign law or foreign practices or something beyond your own borders in order to resolve them properly? I would have said 2 or 3, perhaps, maybe exaggerating a little. I say 15 or 20% now. That's probably understating it. I mean, it's like that. And what does it come out of? Well, these very general words, globalization, interdependence, shrinking world, any other cliche you'd like to use. I say, when I hear those words, and we all hear them, you less perhaps than me might think of why the Charter House of Parma has a good example. Charter House of Parma, great novel, fabulous novel. The hero, Fabrice Del Dongo, is wandering around as a soldier on the field of Waterloo. He was a soldier. That's like wandering around on the battlefield. Bullets are flying everywhere. Horses going back and forth. Napoleon charging this way and that way. And Del Dongo thinks to himself, he's at Waterloo. Something very important is happening here. I wish I knew what it was. Now, we may not admit to that feeling, but sometimes we have it. And so I thought it might be useful to carve out one small bit of this world, the one that I know best, the work of the Supreme Court of the United States, and show you for rather concrete example, I'll give 4 or 5, what it means to say that we can't do our job without knowing more of what's going on outside the United States of America. And that's what I mean by problems continuing to exist, so substitute the name of the country for any name you wish to choose. But let me show you. Let me give you 4 or 5 examples. An important one, start with an important one, where there are very few cases, and there are very few cases here, there are very few cases in the UK, there are very few cases in the United States. Let's use it. Actually, last night we had potatoes, and when the potatoes were ready, music. The first time I've ever been was singing potatoes. It was But in any case, let's start with the problem of security. Security and basic civil liberties. I mean, this document gives, in Article 1, in Article 2, it gives the power to look after our security interests to the President of the United States, to the Congress of the United States, not to the judges. But the judges have the power to look after basic civil liberties. That's the first 10 amendments and others throughout. Fundamental individual freedom. So what happens when they conflict? What happens when the security people tell us that we cannot, in fact, lead exactly the same lives from the point of view of civil liberty that we've lived before? What? At that point, the judges have to get involved. Now, if you look through, and in the United States, and it's coming in Europe, I think more. I think it's coming in England more. We will probably have the last word on something like that. That's another story. We can go into that in questions if you want. Just take my word for it now. But we have to get involved. But although we have to get involved, when you look through the case law on the subject, you see what Justice Jackson said many years ago about the power of the president and the court's review of that inherent power of the president to look after security matters. He said, try to understand the cases on this subject. He says there are only a handful. And when you look at them, when you look at what the founders thought, well, it's like Joseph trying to interpret the dreams of Pharaoh. Why? Because both here and in the United States, I would say, I'm sure there's some who will disagree, but I would say that the governing rule is Cicero. What did Cicero say 2,000 years ago? He said, well, I had a great translation for it. I thought he said, when the cannons roar, the laws fall silent. That's pretty good. Then somebody pointed out the Romans didn't have cannons. So that sort of wrecked that theory. But in any case, you understand the point. In time of war, stay out of it. Not for the judges. War. National security crisis. And our court pretty much led up to that. It lived up to it. You can go back and look in Abraham Lincoln. I mean, it was a terrible war. We can understand his point of view. But he put tens of thousands of Americans in prison, many who were not in the armed forces of the South. And the Secretary of State called in the British ambassador, and he said, you see that bell? I can ring it once, and any person I want in New York will be put in prison. I can ring it again, and anyone I want in Indiana will be imprisoned. Tell me, he said, does the Queen of England have such power? Now, the courts got involved in that after the war was over. After the war was over. Then it's easier. So they did the wrong thing. But at the time, few and far between. Go to the First World War. You will see Woodrow Wilson suppressing speech here, there, and everywhere, his Attorney General. And few cases get up to the Supreme Court, and they typically hold not for the defendant. They hold for the government. You can go to World War II. And in World War II, 70,000 American citizens, 70,000 of Japanese origin, were taken from their homes in San Francisco and sent to camps in the east of California and the Intermountain states, against their will. American citizens. And Was there rationale for that? Well, the Brits there didn't do that. They went case by case. But still, the great opinion written in Britain at that time was written by Lord Atkins, where he thought civil liberties were being run over, and he said, in that opinion, what are we fighting for if we're not fighting for this kind of liberty? His was a dissent. And when the case of Fred Korematsu, feisty guy, friend of my next door neighbor in Cambridge, I met him once. A friend used to work for the Americans, her father worked for the American Civil Liberties Union, representative. My father used to play poker with him. But in any case, they were certain they'd win. Fred Korematsu said they were certain they'd win. He says there's no justification for doing this. The lawyers in the Justice Department looked into it, and they went through all these instances of supposed sabotage and signaling to the enemy and so forth, and they called in the FCC, and they said, well, what about these 783 instances of signaling to Japanese submarines offshore? And the FCC said, not one, not one. They were all buck privates who didn't know how to work the machines. They wouldn't sign the brief, the lawyers. They wouldn't sign the brief. And I thought, well, probably, the Supreme Court, when it heard the case of Korematsu, didn't read the footnotes in the brief too carefully. They had signed the brief eventually. They got Herbert J. Wexler, a brilliant law professor. He wrote a footnote that no one could understand. If you read it very carefully, you'd see. And Charlie Horsky, who was a friend of Roosevelt, argued the case with the Japanese-American Defense League and told the judges, read that footnote. If you don't understand it, you read it twice. They'd read it. 6-3 for the government. 6-3. All right. Now, why? I found in Felix Frankfurter's memoirs his description of the conference after that case was argued. He said Justice Black came in. I mean, the majority were civil libertarians. It was Hugo Black, it was Douglas, it was Frankfurter, it was all the people who later brought us Brown versus Board of Education and desegregated the country. They were on the side of the government, and Black started that conference by saying, somebody has to run this war. Either we do or the president. We can't. And therefore he must. 6-3. Is it? No. Well, then what happened? Well, two things bring us up to date, and then you will see the problem. In the Korean War, the court decided the steel seizure case. The steel seizure case was the power of the president to seize the steel mills so the steel keeps going, so the people in Korea, the soldiers, will have steel so they can have guns so they won't be killed. The court said he didn't have the power to do it. A very interesting case. Jackson then is in the majority, having been in the dissent in Korematsu, and I read it, I say, well, this is an opinion that's written against Roosevelt. It's much easier to write an opinion against Roosevelt if you're on the United States Supreme Court after Roosevelt is dead. Because it was Truman, and he wasn't popular. But they said, no, there comes a point where the president and the Congress have gone too far. And then, to bring us right up to date, 4 cases arise out of Guantanamo. Guantanamo is where they have put the enemy combatants from Afghanistan. Enemy combatants, those whom the armed forces have classified as enemy combatants, some of whom say we weren't enemy combatants. We're just innocent farmers. Well, why did you have a bazooka? Well, all farmers in Afghanistan have bazookas. But in any case, you see, it's a disputed matter, and some want to get to court and say the president lacks the power. Congress passes a law that says none of these people can go to court. The statute says not one of them can get into a court. And our court, 5-4, in a case called Boumediene, says that's unconstitutional. There we are. They can get to court. And some, but not all, are gone from Guantanamo. The interesting thing to me about that, which I joined, it's during the security crisis, is Sandra O'Connor's few words in one of the 4 cases where she says, The Constitution does not write a blank check to the president, not even in time of war. I agree with that. What's the alternative? Korematsu. All right, no blank check. But it will take you 2 minutes from the time you heard me say that to begin to think, very well, no blank check. What kind of a check does it write? There we are. And now perhaps you'll begin to see why no one liked our decision in those Guantanamo cases. One group thought, what are you doing interfering with the president? The other group thought, why aren't you more specific? Why do you just speak in these generalities and say they can get into court? Why don't you say you have to release them? Or why don't you say they can't use hearsay? Or why don't you say... And the answer to all those details is, of course, we don't know. And the answer to why did we get into it all? Well, what's the alternative? Do you want Korematsu? I mean, there we are. Now, I've summarized it, simplified it, etc. But I want you to see where we are. And we do meet with British judges from time to time. We met last year and we're meeting again this year. And we discuss these matters. And I would say they're not so much more certain about what to do than we are. Nor would you be if you were in my job. And so I have to end up with something that's almost trite. I have to say, if you want us to take this job on, and I do think we should take it on, I do, because I don't like either of those two alternatives. Very well. How do we find out enough about national security? Are we just supposed to listen to whatever the government says? Are we just supposed, what? We're not defense experts. And by the way, how do we find out what other countries do? We're not the only country in the world, that has civil liberties. We are not the only country in the world that has problems of terrorism and security. And so looking forward, that's the kind of problem that we will, in my opinion, face more and more. And so will you here. So will you here. Absolutely you do. And then you try to work it out. Not believing, I hope, that judges have the magic solution, because they don't. Best they can do is to read what they're told to read. And that, to me, means we ought to find out, and I'm glad we're meeting with the British judges, what do they do here? What do they do in Israel where they have problems like this? I know a little bit about that. If you have to bring somebody into detention, the army has to explain why. All right. Does it work? Okay. The army has to explain why, and have to explain why you can't have a lawyer. They'll say you can't have a lawyer. Why not? Well, he'll say, tell my mother hello, and that means blow up the cafe. You mean you want us to hold him without a lawyer? Only temporarily. Come back next week and tell us why still. And then come back 2 days later. And come back 1 day later after that. And then 6 hours. And keep telling us why. Why you can't give him this lawyer yet. Or. You see the idea? That's an approach. What you have as an approach is you have what's called, I think, the lawyer who's the lawyer for the client, but he can't meet with the client. There's a second lawyer who meets with the client, and the first lawyer meets with the client's lawyer and then sees the national security matters that they may not want the client to see. Does that work? Well, your courts are in the middle of that one. And there are quite a few other systems. My only point here is the world is such that we have to know something about it. Unless, of course, you want to go back to Korematsu. Or unless, of course, you want judges ignorant of the subject to try to resolve the correct equilibrium between security needs, where they can be absolutely real, and the problems of civil liberty. Well, I've given you a sketch of that. Let's look to commerce. That's more obvious. But commerce, they are coming up regularly. Everybody please turn off his telephone. This is so typical. What?
It's not the president.
Probably my grandson. They're all over the place. Plaintiff, Ecuador, vitamin distributor. Defendant, vitamin manufacturer from Holland. Part of a cartel that raises the price of vitamins. Lawsuit brought in New York under American law. Why? Well, it's possible the vitamin price was so high that this poor distributor couldn't afford them, so he got too weak and he couldn't get further east. So that's one possible explanation. There is another, which is called treble damages under American antitrust law. Of course they want to sue in New York. The damages and the attorney's fees are high. Can they? Well, we have briefs in those cases. Briefs filed by the EU, briefs filed by Britain, briefs filed by Canada, by Japan, from all over the world. And if it's relevant to you, working the answer out in those cases, which, by the way, is interpreting a statute that's an American statute which does speak about this, and anyone who can understand what it says gets a double medal because it's 14 times more difficult than the statute I just talked about in the Korematsu case. Well, what's the answer? What's the answer? Now, what was interesting to me in that was to discover that already there is a sheet of documents like this that represent the working arrangements between the cartel authorities, in the anti-cartel authorities in the EU and the antitrust division of the United States Justice Department. And what used to be, a few years ago when I was starting out in the department, we had the same kind of thing, and there were meetings with the people in the UK Monopolies Commission. Professor Yaney, he was great. He knew all about retail price markets. And there were French and Japanese and so forth. I mean, the documents were the key because those were the working arrangements. And I don't think we could have decided that case intelligently unless the EU, the UK, and a large number of other countries had given us briefs that gave us the information which was, in my opinion, necessary to get those different systems of the different nations in the antitrust area working harmoniously together. Same thing with securities. Buyer, Australian. Seller, Australian company, stock exchange, Australian, and that Australian company has bought an American company in Florida, where, says the Australian plaintiffs, they paid too much for it, it was fraud, and that fraud took place in Florida. We want to sue in New York. They all love to sue in New York. I don't know, it's not that pleasant a climate or anything, but nonetheless, can they do it? Answer, we said no. Sue in Australia. Why? I don't think we would have come to that conclusion 20, 30 years ago. I think it would have been a different conclusion because it was a different world. But we saw right in front of us in that case, briefs again, but briefs filed by countries all over the world, and including the UK, where they're telling us if you decide it this other way, you're going to really muck up our own system for dealing with fraud. So don't do it. And what you see is a court trying to use that information to try to work out a system of securities fraud regulation that will work together harmoniously. And the word that we use is called comity. And the wonderful thing about comity is it sounds terrifically technical and no one knows what it means. But basically today, it means trying to work out these things together. We have a copyright case. A student from Thailand is studying at Cornell. And his textbooks, identical, in English, are sold in Bangkok at about half the price, a much lower price. So he gets a bright idea, says to his parents, send me a few. And they sent more than a few. And he was making quite a lot of money out of this. And the publisher got very annoyed and brought a lawsuit. Can he do it or not? Again, it depends on a technical provision in a statute that's an American statute that's pretty incomprehensible. I go into my office like that. Like that. Lawyers from all over the world. From Asia, not just Thailand either. Japan, Netherlands, UK. Oh, the UK and Netherlands are great because the government filed briefs in each of those cases saying do one thing, and the lawyers, groups of lawyers followed from the same country saying do the opposite, our government doesn't know what we're talking about. That's normal in our country. But we had them from all over, and I couldn't figure out why this was such a big, enormous deal, frankly. Until I got down into that pile, and one of the briefs told me, you know, copyright today is not just a matter of books, or books and music, or books and music and film and so forth. It says today, automobiles are copyrighted. What? Software. Software can be copyrighted in many places. And by the way, go into any store you want, and you will see labels. They're all copyrighted, or almost all. And by the time you get finished with your holding, you are going to affect $3.2 trillion worth of cars. Hey, well, even today, $3.2 trillion is a lot of money. Yes. All right, I'm trying to give you a picture of what life is like in cases like that. Or go back to human rights. I mean, a great case in human rights. Dolly Filartiga from Paraguay in the 70s comes to New York. And there in New York, she discovers the Paraguayan man who tortured her brother to death in Paraguay. And she also finds a statute passed in the 1790s which says an alien can bring a lawsuit in a federal court in the United States and receive damages from a breach of the law of nations. Ah, the law of nations. What were they thinking of? Pirates. Probably pirates. In part pirates. Because it used to be the rule, I guess, in 1790s that if you found a pirate, wherever you found him, you could hang him. And on the way, if you hold him upside down and money falls out, you give it to the victims. And this statute more or less replicated that. And she says, who are today's pirates? Certain torturers. Certain torturers. And the court said, yeah, that's right. And she left, and she said, I came to the United States hoping to look that torturer in the eye, and I came away with so much more. Not money she wasn't. She'd gotten what she wanted. A judgment, which he never collected. But soon after that, more and more cases are brought, because human rights violations take place all over the world. And now what? How do we confine this statute? How do you interpret this statute? Who are today's pirates? And that's harder than it's harder than you'll think at first. It's harder than you think for a few reasons having to do with the international aspects of this kind of a statute. I mean, law of nations. What exactly is that? And who's to decide? And remember, and here I do retreat to America. It's America, this problem. But Madison said that this document here is a charter of power given by liberty, not as in 18th century Europe, a charter of liberty given by power. Now, no one knows what that means, but what he means is this, that if you look at France, 18th century particularly, or Britain too, to a degree, maybe a little bit before the 18th century, or most of the countries of Europe, what you'll describe as legal authority or sovereignty or legal power starts at the center. Now, they might give to their citizens liberties, right to vote, etc. But the source is the center. But the source of the federal power in the United States is not the center. The source is liberty. The individual, the person, starts free, and if he has not, in this document, delegated the power to the central government, the center doesn't have it. You see the difference in attitude? Now, if you think that's just an old-fashioned history, try talking to a few of the people I talk to. Because you don't have to probe too deep until you start getting this. Well, this is an American Constitution. Where I got that for you. Got that for you. How strong you felt. But more than that. I mean, I know who the president is. I know who the senators are. But who are all those people over in the International Court of Justice? Who are these judges over in Europe or even in Asia? Who voted for them? What have they got to do with me? You say, be careful with that attitude. But you can understand it. You can understand it. Who are they? I mean, I can sometimes vote for a judge. You know, we have 10,000 of them elected. I mean, that's a problem. That's another problem. The federal judges are not elected. if they're appointed by the president. But still, I voted for the president, and the Senate confirmed that individual. And so there's a connection there. But who voted for the people who are writing this international law, whatever that may be? They're professors. Nobody voted for them. You see? Now, my point is there's difficulty in interpreting this statute, which we must interpret. And what about some of the cases brought? Talk about slavery. And the defendant says, we didn't engage in slavery. Our working conditions were tough, but that is a matter of labor law. We didn't engage in destroying the environment. We just threw the odd bit of, rat poison up the tree or something, whatever. But most countries have systems for drawing that line, which depend upon experts in labor law or experts in environmental law, not judges in New York. Or what about South Africa, which filed a paper in New York, in the court, in a case which said that apartheid was against the law of nations, and this company contributed to it, the defendant. South Africa filed a document saying, stay out of it. We have our own system called Truth and Reconciliation for dealing with the effects of apartheid, and the last people we want in this are a few federal judges in New York. Now, how is the federal judge supposed to treat that piece of paper? Is the State Department to have free rein to tell him what to do? Very difficult. Very difficult. Or if you get through those, you'd better remember this, that if in fact we are going, and judges know this, and lawyers know it, it's called precedent. We say it's fine to bring a lawsuit against this horrific thing, which the alien did abroad to this other alien, and pretty soon other countries say, well, we can do the same thing. And before you know it, they decide the obvious defendant is Henry Kissinger. He's the one who's sued in all these cases. I don't know why, but poor Henry Kissinger is viewed, you see, and the country says, we don't want that. We don't want that. So my point here is that when we're deciding the meaning of a statute, such as I gave you, all these other problems come up. And more, in my opinion, judges throughout the world, when they have similar circumstances, have got to figure out or try to figure out what the generalized effect in other countries will be through the principle that they announce in their opinions. And the reason they have to do that is there is no Supreme Court of the world which can iron these things out. Or take another easier case. You realize that we've had 4 cases, or 3, involving treaties. Involving treaties about abducting children. I think 3 cases in 2 years. That's a lot for a single treaty. You only have 75 cases or so a year. Why? And what they involved, abducting children, I mean, here they're often difficult to interpret. On one side, you have a group of people who spend their lives trying to prevent children from being abducted, an absolutely worthy cause. And on the other side, you have people who spend their lives trying to prevent women being abused. And that's one of the reasons they say the children were abducted. A worthy cause as well. And they're trying to tell us both how to interpret this statute, which, by the way, is in opposite directions. That's the world. I mean, that's the world from my point of view. Lots of cases. How many of you think, by the way, how many of you think this? This is a good question to ask. There are treaties all over the place, and of course we interpret treaties, and of course when we do interpret treaties, we have to pay attention, and nobody denies this, to what other countries and what other courts are saying about the proper interpretation of the same treaty. My friend Professor Cassesi in Italy had his 14 law students looking up the answer to this question. How many organizations, this group will know, but how many organizations do you think there are, call them treaty-based or executive agreement-based or something else based, where they have the authority? What they have is they have some kind of treaty or document. They have a kind of bureaucracy or administrators from several countries, and they make rules. And those rules, in practice, bind more than one nation. All right, have you got the picture? You understand what I'm talking about? An organization, multinational, like the UN or the International Trade Organization. There is a staff, they make rules, and those rules in practice bind more than one nation. They bind Britain, They bind the U.S., they bind others. They bind more than one. Now think of the number. I mean, ITO is obviously one. UN in many respects. How many think there are more than 100? How many think there are more than 500? Or more than 1,000? More than 2,000? All right, there are more than 2,000. There are more than 2,000. And we, the United States, belong to about 800. I got my legal assistants to look it up. I mean, there are things you've never heard of. There's some you have heard of. Bluefin Whale Commission, International Civil Aviation Authority. There's nothing wrong with those. International Olive Oil Council. I'm not sure everybody's heard of that. But they're all over the place. Now, what's the status of those rules? Try Ball. In Ball, we have banking meetings. And the banks come to meet. And who do they meet with? Regulators from our Securities Exchange Commission, regulators in other parts of the world. And what do? Figure out what the right rules would be. And who promulgates the rules? Well, they go back to their own country and promulgate them. And then they say to the people who are affected by them, come in and comment. What do you mean come in and comment? You already decided this over in Ball. Okay? I'm just giving you a quick state of the art. And they're all over the place. What's the organization that probably has just affected you 50 times in the last hour and you won't even think of it? ICON. Everybody know what ICON is? ICON? Domain names. Regulates the internet. You know what it is? It's a private corporation incorporated in Los Angeles, California. Okay? They're all over the place. They have all kinds of status. All kinds. And do they have legal effect? When? Where? Depends. The IC, all the Civil Aviation Authority can do is tell you no, or you can't fly. That's pretty good effect. All right, and so what's their status? Now, this is a question you have had legally, and here you come back to the EU. We have Germany, we have Italy, we have Austria, and each of the Supreme Courts of those three countries has said that the court in Luxembourg does not have legal authority. It does not have legal authority to tell them what to do in respect to everything. There have been reservations. They haven't yet found one that was binding, but they've said they're reservations. So I say, what are we going to do? If we say that Congress can give all these organizations whatever authority they want, is that the... Suppose we say no. Then how do people today solve problems like security, like environment, like health, like commerce, on and on? Because the whole last 45 minutes has been to try to describe to you what those problems are in some depth in one court. General enough so you can get it, but deep enough so that you see it's a big problem. And that is the world today. And indeed, if you say Congress has power to deal whatever they want, no power, how do we deal with it? Whatever they want, hey, what happened to Article 1 of this Constitution, which said the Congress of the United States shall have the power to legislate? That's one we haven't had to decide yet. Yet. Right. Now, have I given you a picture? And I'd say I want to give you the picture because it seems to me what I've been telling the people who say, but it's an American Constitution, I say after at least 40 minutes and maybe more if you read a little further, can't you see that I think if we say goodbye world, it's going to affect us anyway? Because these problems are not arising out of somebody's philosophy. They are not arising out of some attitude of a judge. They are not arising because he's a liberal judge or a conservative judge or any other kind of a judge. They are brought upon us by the nature of today's world. That's what it's about. And it seems to me that you have the best way, in my opinion, is to preserve our American values, is to participate in what will be an effort, maybe problem by problem, maybe by groups, maybe through all kinds of different kinds of organizations. There isn't only one way, but there are ways of doing better at this rather than less well. And to understand it and find out what's happening abroad and to understand more about the nature of the problem, that's how we solve our problems. That's how we solve our problems under law. That's how we solve our problems under law rather than the alternatives. And that's the point I want them to take in internally. If I'm talking to the young ones, I say, I still hope that you remember what you learned in school, which my wife has been trying to teach my grandchildren. She's offered them $20 if they can memorize it. Lincoln's Gettysburg Address, because he starts that address by saying, 77 years ago, our fathers brought forth upon this country a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. Why 87? That gives us back not to the Constitution, but to the Declaration of Independence. And it's in that document that it says all men are created equal. And we are now engaged in a great war to decide whether that nation or any nation so conceived and so dedicated can long endure. I said, what's he talking about? I found it. My law clerks looked this up. It's George Washington's letter, if I have it here. A letter to Catherine McCall. And it has in one sentence what those framers are thinking. What they're thinking, that government they created in 1789, they are thinking it is the last great experiment for promoting human happiness by reasonable compact in civil society. Experiment is the key word. In 1789, there was nothing like it. There was nothing like it, which is going to depend upon democracy, which is going to depend upon a degree, and it didn't extend everybody, believe me, but it did. It was an advance. And that's why Lincoln wants to fight that war in part. He doesn't want the place to fall apart. Because if it falls apart, that experiment failed. And that's what it is. And so I want to tell the high school students in America anyway, and you're part of that experiment. Because it isn't over. You say, what is it an experiment in? It's we're taking that technical stuff I was talking about. Taking that technical, boring detail, and if you think it's boring when you hear it in 40 minutes, try in a period of 40 days. I mean, my God. All right, but take it and try to work out different solutions through rule of law. And it's a little emotional, but the French writer who appeals to my generation most is Albert Camus. And what he says at the end of the play, my God, that resonates. It resonated with me since I've been in college. He's written about the plague. He's written about the plague in Iran and how they react. He's really talking about the Nazis. He's talking about the Nazis in France. And he says, why did I tell this story? He says, I told this story. I wanted people to know what they lived through. I also want to write about doctors, because doctors are people who just do good without thinking about it. They don't have a theory. They just do it. But most of all, I wanted to say this because the plague germ, the germ of that plague never dies. It goes into remission. It lurks inside of human beings. It lurks there, one day to emerge for the unfortunate destruction, education of mankind, once again to send its rats forth into a once happy city. Yeah, says that's it. That's the alternative to the rule of law. And we're there, I think, in part, I say to the judges of the law students, but really all of us, we're there because we don't want that alternative. We would like the alternative we call, under the boring name, rule of law. Many, many ways to skin that cat. Many, many ways to bring about a society that can, in fact, do a little better in dealing with these problems that are now worldwide. And I guess the whole point of this is to say any effort to do such a thing in today's world has to be cooperative. It has to involve you, it has to involve us, it has to involve many other nations as well.